Morning. Thank you.
SJC-08921, Commonwealth versus Chatman.
Thank you.
All right, let's proceed. Good morning.
Good morning, Your Honor. May it please the Court, my name is Edward Hayden. I represent Demond Chatman. He was convicted of first-degree murder for the murder of his mother. The background to this case is that Mr. Chatman has had a lifelong struggle with mental illness. He's been diagnosed with paranoia, schizophrenia. He's also mentally retarded. Demond did not bring his condition to trial counsel's attention at any point, and counsel did not ask him about it. So counsel went through the whole pretrial preparation and the trial unaware of Demond's mental condition. At the trial, Demond sat there and did nothing, said nothing. So the trial judge was also unaware that he had these problems. But there was a problem. Demond could not do the things that are required of a competent defendant. He couldn't rationally consult with his attorney, and he did not understand what was going on.
And that's based on Dr. Joss's report 5 years later that you come to those conclusions?
Well, that's one of the things, Your Honor. Dr. Joss started his evaluation of Demond about 3 years after the conviction. He didn't write his report until 5 years later, but yes, I mean, that is probably the strongest evidence we have that Demond was not competent at the time of his trial.
I don't want to say that these unusual things don't happen, but you have an experienced trial judge, you have an experienced defense lawyer, an experienced prosecutor, you've got court officers that are moving him back and forth, and you have people from the House of Correction where he's being held pending the trial. And nobody says there's something wrong with this guy.
Well, Judge, first of all, he was held at 2 houses of correction pre-trial. He was held in Suffolk, and for whatever reason, he was transferred to Cambridge for a while. And the records from both of those houses of corrections indicate that they were picking up on the mental health issues. They didn't relay that to anyone involved in the trial.
And there's something a little bizarre about that.
I agree with Your Honor.
They oftentimes tell the defense lawyer, there's something wrong with your client.
Well, anecdotally, Judge, I have been at the Bureau of Prisons, and correction officers have told me, you got to get this guy out of here. There's something wrong. He doesn't belong here. Now that, I don't know why no one ever brought this to Attorney Bonastoli's attention.
Didn't second chair say something in an affidavit later?
I'm sorry, Your Honor?
The second chair.
Oh, yes. At my request, the second chair attorney wrote that she was picking up that something was wrong with Demond. And the other thing, it's
Could I just ask you, because I don't remember, did she say anything in the affidavit about whether she conveyed what she was picking up to John Bonastoli?
She did not say that. And I don't know why.
To what extent is your argument based on what I got from Dr. Joss's report, that this was the way this particular defendant's illness manifested itself was not in overt behavior, but in fact just the opposite, non-responsive, non-communicative, and it was only if you, I think, started him talking that he would eventually begin to display some of the symptoms that he had.
And that is the pattern. It's not only with Dr. Joss, but it's my experience with Demond that once he gets started, it is so clear that there's something wrong with this guy that there I don't know how anyone, I mean, if you let him talk, it's obvious that he has issues. The lack of eye contact, he's looking over your head, and he starts rambling on about the Nation of Islam and Muhammad.
Well, he had
Elijah.
conversations with police, didn't he?
He did, at the interview. But the other thing interesting about that interview, Judge, I mean, is someone who's being investigated for the murder of his mother. I mean, Dumond cannot tell the police enough how much he hated his mother. He just loathed her, and he is very anxious to tell the police that. And I think that tells you something, that this guy is not doing a good job defending himself when he's volunteering this information about his hatred for his mother.
Was his statement videotaped?
It was audio taped. I don't believe it was videotaped, Judge. It was so long ago.
Yeah.
The 2000? Was it 2000?
2000.
Can you hear? I mean, did the police ever get angry with the guy and say, "Look, you're lying. You're not telling us the truth. Just fess up"? Did they ever say anything like that? I mean, were they angry with him?
I don't know if I don't know if they directly. I can't remember, Your Honor, to be honest with you, whether or not they directly confronted. I mean, certainly they were skeptical about what he was saying because his alibi is so weak. I mean, he forfeited a valid defense of lack of criminal responsibility by going forward with this really futile alibi defense. But that's exactly what he told the police, that he was out jogging at Franklin Park, and no one believed him.
Can I ask you this? You've got the trial judge who reviewed all the affidavits. She watched the trial. She was observed both the defendant and counsel in the course of the trial, and she concluded that there was an insufficient basis here to grant either a new trial or to grant a further competency examination. So what's the standard we use to evaluate her decision?
Well, whether there was an abuse of discretion.
Abuse of discretion, you would say, is the standard.
Correct. And I think there was in this case, because she disregarded Dr. Joss's opinion. And there's no question about Joss's qualifications and the work he did to form his opinion in this case. But I think the judge based her decision primarily on the fact that she did not feel that you could determine someone's competency post-verdict, and that there was no evidence, objective evidence at the time of the trial. But that is not the standard. And I mean, the case law she cites doesn't support that position.
Well, were there any other opinions offered by experts concluding that he was not incompetent?
Not incompetent? No. I mean, I have been asking the DA's office to have him evaluated. Just get their own expert in, and they wouldn't do that. But now, at one of the post-trial hearings, Dumond blurted out, he swore at the judge. And Judge Rouse ordered that I have Joss evaluate him to determine his competency to proceed with the motion for a new trial. So Joss again evaluates him, finds the same conditions, same symptoms, and determined that he was not competent to proceed with the motion for a new trial. Judge Rouse disregarded that opinion and then got a psychologist from the court clinic, a Dr. Levitt, to evaluate him. Dr. Levitt concluded, in effect, that Dumond was not competent. I mean, she said he was competent if he didn't have to do anything, but if he had to participate in the hearing, he was not competent. And I think Judge Rouse agreed with that because she stayed the proceedings, had me ask the Department of Corrections to try to get DeMond competent to proceed with the motion for a new trial. And so I begged the DOC to start administering medication to him. And it was obvious that within a very short period of time that he had improved. His rambling responses to questions had stopped. He was clearly more rational. So I informed the court of that, and Judge Rouse ordered Dr. Levitt to go back and evaluate him approximately 3 months after the first evaluation. And at that point, Dr. Levitt concluded that he was competent to proceed with the motion for a new trial. But the important thing is that DeMond, his pattern, the only thing that alleviates his problem is medication. And he was not medicated at the time of the murder, and he was not medicated at the time of the trial. And he was exhibiting the same symptoms. I mean, Dr. Levitt was coming up with the same diagnosis, the same symptoms that Joss was noticing.
But it was 10 years later.
Correct. I mean, but
Years after the trial, but 10 years after the event.
Correct.
But the trial's what matters. So it's 8 years afterwards. So wouldn't you need something to say this is an immutable condition, that once you've got it, it doesn't change? And so if he has it in 2010, 2009, and 2010, he had it in 2002?
Well, I mean, that's what Dr. Joss, that's what his opinion was about. However, we also have records from DeMond dating back until he was 7 or 8 years old. And, way back then, they were saying that he had these psychological conditions.
But I guess all I'm saying is, I don't doubt any of that. And the fact that a person suffers from schizoaffective disorder, whatever, doesn't necessarily, I don't think, translate that at a particular point in time that person is incompetent to stand trial, as opposed to having a serious mental illness. And so it's having to get to that point of incompetence that just the fact that he suffers from schizoaffective disorder doesn't translate into he is therefore incompetent.
Well, no, I agree with Your Honor. However, in this case, Dr. Joss said that it did. And I think we should give his opinion some weight. He's the expert. But in addition, we have the second chair attorney saying he wasn't assisting in his defense. And the other issue is that he went forward with this futile defense of alibi. And why wouldn't, if he had been competent, why wouldn't he have volunteered this information about his mental condition?
Well, I take it he insisted that he didn't do it. So,
Well,
I
I
mean,
mean,
that's sort of the client's choice when it comes down to the end of the day.
if he's competent, it would be a valid choice. But I think this is where an evidentiary hearing...
But you're saying he made a bad choice, therefore he must be incompetent.
Well, I think I prefer to phrase it as that he made a bad choice because he was incompetent. And I think this is where an evidentiary hearing would have been helpful, to have a trial counsel testify about how did you get to the point where you were going forward with this alibi defense? The judge put a lot of weight in Attorney Bonastoli's affidavit that he didn't mention that he didn't have a defense of lack of criminal responsibility, but didn't deal with the issue that I asked Attorney Bonastoli repeatedly to give me an affidavit on the issue of competence, and he refused to do that. And the judge also claimed that Dr. Levitt, the psychologist that evaluated him for purposes of his competence for the motion for a new trial, did not opine on the issue of whether he was competent at the time of the trial. And she didn't, and that, she wasn't retained to offer that opinion. And again, I've been trying to get him evaluated by someone independent.
May I ask you, have we had other cases where a person has been evaluated years after the trial regarding their competency?
Oh, I think there have been cases. I think the two strongest cases for the defense on this case are Conahan and Atkinson. But I concede that I could not find one case where no one picked up on any red flags during the course of the trial. In other cases that, there was some indication that there was something wrong with the defendant, but they proceeded with the trial. But I don't think the standard is that the defendant has to exhibit symptoms of his mental health problems during the trial. DeMond just sat there through the entire trial, didn't say anything, didn't do anything.
That's based on Sarah Church, or I'm not sure I got the name right. The based on the second chair's view, that he just sat there through the entire trial.
Well, no, but I mean, actually, in the transcript, I mean, he doesn't say anything.
Well, that's not very unusual.
Well, yeah, I mean, he doesn't. But there was nothing for the judge to. I mean, the judge is saying, based on her 18 years of experience, et cetera, she didn't pick up on anything. But see, my argument, that's an abuse of discretion because there was nothing for her to pick up on. He just sat there like a lump, and there's nothing for her to form an opinion on.
But so when you, all I'm wondering, when you say he sat there like a lump, is that based on the fact that you see nothing in the transcript that indicates he's doing anything?
Correct.
As well as the second chair's affidavit?
Correct. And, I mean, again, this would have been, an evidentiary hearing would have been helpful to find out what defense counsel had to say about what DeMond did to assist him other than merely saying, I didn't do it. But the other thing, I mean, isn't that telling the lawyer, I just didn't do it, an indication that he didn't trust his lawyer? And that because really the key question, the key issue on the defense is the paranoia. I mean, was he able to trust his lawyer or did he not trust him? And we have all these affidavits from people who knew him when he was younger that he just couldn't trust people. And Joss is picking up on it when he's evaluating him. The judge, not once did she address the issue of his paranoia. And that's the key question.
May I ask you this? Did Dr. Joss ever interview the attorney?
No, because he wasn't cooperating. He wouldn't respond to me. Now, I don't think Joss ever even tried to call him, probably because I'm telling him that the guy's not cooperating. I mean, he's not giving me anything. So we don't have what DeMond did to assist. And again, the paranoia is the key issue here. And it's easy to say that DeMond was malingering. But Joss is the one who sat across the table from him, interviewed him 3 times. I think he talked to him once on the phone. And Joss is the one that's experienced at doing this. He tested him to determine whether or not he's malingering, and he didn't think so. So it's easy for either the prosecution or Judge Rouse to say, well, DeMond was malingering when he made these comments. They're not the ones that interviewed him. They don't have an expertise in this area, and they didn't test DeMond to determine whether or not he was malingering. But his comments concerning his racist and homophobic comments about the various participants in the trial, Joss felt that was a result of his paranoid delusions, and he didn't understand what was going on, and that's why he made these comments. But to simply say that, DeMond is a racist, he's bigoted, he's sexist, it's easy to do that just based on the comments, the substance of the comments themselves. And but Joss is the one that interviewed him and didn't think that he was malingering. So we're asking, Your Honors, to just, Your Honors could, I suppose, order that this be sent back to the trial court for an evidentiary hearing. But we're requesting that Your Honors just simply grant him a new trial. The evidence that DeMond was incompetent is simply overwhelming, and there's no counter evidence to that. The DA's office has taken the approach to not have him evaluated over the past 10 years. They concede it's difficult to determine competency this long afterwards. We're requesting that you simply grant him a new trial.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Kaylin Campbell on behalf of the Commonwealth. The real issue here today is whether the motion and the affidavits submitted by the defendant made an adequate showing with regard to the defendant's alleged competency at the time of trial. And the motion judge did not abuse her discretion in finding that the defendant did not make an adequate showing as to this regard. And the question really is whether the judge did abuse her discretion, meaning that no conscientious judge acting intelligently could have taken the same view as she did. Now, my brother conceded that the best evidence and the only...
That goes both to the merits of her decision and whether or not an evidentiary hearing would have been helpful. She didn't hold an evidentiary hearing.
She didn't hold an evidentiary hearing.
Does it go to both, whether or not...
I would say it would go towards her decision that the defendant did not raise a sufficient claim here. And then I disagree with my brother and think that if you were to conclude that she erred in that way, that an evidentiary hearing would be necessary in this instance. Because under Rule 30, if a defendant does make such a showing, he is entitled to an evidentiary hearing.
Well, how substantial does the showing have to be? I mean, there's a lot of material submitted in support of this. 2 doctors examined him carefully, medical records.
Yes, there were a lot of documents submitted. I don't think that these documents necessarily spoke to the defendant's alleged competency at the time of trial, which is the appropriate focus that this court should be looking at.
How do we do that when in the circumstances of a case like this? Let's just assume for a moment that he was indeed incompetent at the time of trial. How does one go about proving it? One can't go back in time and have him examined at the time.
No, Your Honor, and I agree with that. I would point towards the cases where there was a post-trial retroactive determination of competency, specifically Commonwealth v. Atkinson, which is an appeals court case, and look at the showing that the defendant in that instance made there, in which, in that case, she had individuals who were around her at the time of trial, including her attorneys, who stated to the effect of, we believed that she was suffering from battered wound syndrome. We observed these type of behaviors. It was hard to communicate with her. It was hard to determine what her defense should be at trial. She did not go forward with this defense. In that case, her husband was so controlling that he, in essence, fired the attorneys that submitted the affidavits with her. There also was, in that case, a long history of abuse of this individual against that woman. So I'd say that in a case like Atkinson, it could be shown, because there was evidence from the time of trial that would support that this was a condition that affected both her decision-making and her ability to rationally consult with her attorney at the time. I think that type of evidence is absent here, and I would turn the court specifically to Attorney Church's affidavit and what it says and what it doesn't say. It does say that the defendant rarely answered questions posed to him, but it also says that they consulted with him every morning at the beginning of trial, that the defendant was always polite and courteous to her, that when he used bad language, he apologized to her, and it also says specifically on page 92 of the record appendix that when he was in court, he appeared to be listening to the witness's testimony.
What do you do with the evidence that suggests that's just part of how he presents? That's part of the problem, because initially that's what he looks like, and it really masks the true nature of the problem.
Again, I would point to Attorney Church's affidavit in which there's an absence of any type of assertion that it was impossible to communicate with him, that he didn't seem to understand what was going on, that he didn't seem to have a rational understanding of what was going on at the time. I would also say that, yes, my brother does assert that these mental problems were so obvious to him when he met with the defendant post-conviction, but it clearly wasn't so obvious to any of the other people who had interacted with him throughout this time. This court in Commonwealth v. Goodrell, which is cited in my brief, said that the best evidence as to the defendant's alleged incompetency at the time of trial comes from his attorney himself and those that interacted with him at that time. And here what you have is you don't have any kind of assertion from anyone who interacted with him at that time that there seemed to be something wrong, something that was so obvious to my brother. And I would also disagree with my brother's assertion that the prison records from both the Suffolk County and Middlesex jails support that there was something wrong. If you do look at those records, specifically the mental health records, they do indicate that they were speaking with the defendant, but they also indicate that those individuals who were trained to screen for these types of things didn't think that there was any kind of acute mental problem that needed to be addressed. So it's both the prison officials, his attorneys, and the court, no one noticed that there were anything that was so obvious post-trial as to the defendant's alleged incompetency. And I would say that under the current state of the law, it is the defendant's burden at this post-trial motion to provide any sufficient credible evidence to support that he wasn't competent at the time of the trial. And if the court has no further questions, the weight of the evidence in this case established that the defendant killed his mother by shooting her in the back of the head in his bedroom at 20 Maywood Street in Roxbury, that he dragged her body into his great-aunt's bedroom, tried to throw her out the window, and failed, leaving her naked body in the room. For this reason, we ask that you uphold the defendant's conviction for first-degree murder.
Thank you, counsel.
Thank you.